Morning, everyone. We'll just wait a moment while the rest of the folks come in from the waiting room. Yes, while that's happening, I'll go through a few of the housekeeping items that we normally go through at the top of the Q&A. First, if you could make sure you just stay muted unless you have a question. That helps us not get too distracted. We do have a light load of questions today, so we may be able to get to additional questions at the end if you want to put questions in the chat. Just a reminder that all of our discussion today is general information. It is not legal advice. And feel free, again, to use the chat for questions or clarification. But again, the commentary in the chat is not legal advice either. Couple reminders. We've had lots of conversations about the Corporate Transparency Act. It is still being challenged by National CAI, and we do recommend holding off. We've been saying till October, which is coming up fast, before attempting compliance, but we'll keep discussing that. Chelsea, are you able to mute that? Okay. And a reminder that CA Day is coming up on October 5th. That's the annual WSCAI conference. Katie and Ken are going to be doing a presentation this year on what you must do or can't do when Wakiowa becomes your statute, or when it is your statute. And then Valerie is going to be co-presenting with the WSCAI lobbyist and the chair of our Legislative Action Committee on a 2024 legislative update. So we hope to see you all there. You can go to the WSCAI website for more information and how to register. Ken, anything to add before we jump into the questions?
No, I'm good, thanks.
Okay. First question. Can you please explain what topics are allowed to be discussed in closed executive session in an HOA RCW 6438 board meeting? Our board is claiming that they can engage in peer-to-peer discussion in closed sessions. Is that within the scope of what is allowed? The short answer to this question is no. If what you mean by peer-to-peer is chatting amongst each other or having conversations regarding topics that are not specifically allowed under the statute to be discussed in executive session, those are not proper for executive session. They should be held in the general meeting. RCW 6490.445 subsection 2 tells us that an executive session may be held only to consult with the association's attorney concerning legal matters, to discuss existing or potential litigation, mediation, arbitration, etc., to discuss labor or personnel matters, or to discuss contracts, leases, commercial transactions currently being negotiated. Things like bid proposals and that sort of thing also fall into that. There's a more lengthy list if you look at the statute itself. And then also the final one is to prevent public knowledge of a matter that the board or the committee determines could violate or would violate the privacy of a person. So if it is not, if your discussion amongst the board members is not about one of those things that I just mentioned, and I can say that most of the times I see the executive session minutes when I'm doing a collection matter and those things are discussed in executive session, that is not the proper place for it. It should be done on the record, and we've talked about it a lot in prior Q&As. I think the thought process of board members is we should kind of keep this stuff private from the rest of the community. And the real thing is the legislature, the statutes, the goal is to have open meetings, is to have your community know what's going on, except if it's in one of those really narrowly tailored parameters. So the default should be to have an open discussion. I did want to point out also that what you're doing in that executive session, if it does fall into one of those things, let's say you're talking to your attorney, or you're talking about advice your attorney gave you on a particular matter, you can discuss it in the executive session, but then you need to go back out to the general meeting once the executive session has been ended and have the vote on that topic be held during the regular session. So for example, again, in what I normally do in collections, the board may go into executive session and say, condo law said we should consider foreclosure. They can discuss it there. They need to come back out to regular session and say, I move for condo law to proceed with foreclosure, and then the votes and et cetera happen on the record for the regular session meeting. And then again, know your statute and whether open meetings are required. But generally speaking, if you're subject to open meetings, or even if you're not, executive session is only for those specifically laid out parameters. Anything I missed there, Ken, you want to add?
Well, I think the conspiracy theorists of the world have convinced the legislature that HOA boards are hiding lots of information and discussions and making secret backroom deals. And so they have tried to essentially force all of the associations to be more open. And I don't believe that most associations are trying to hide information. But when boards start to talk about these, I'll say, peer-to-peer private discussions, it encourages the conspiracy theorists to believe that they are being, deceived somehow by the board. So it's certainly our recommendation to hold the open meetings, have the discussions in the open meetings, and it doesn't matter that people have more information than what you might have given them in the past. And I think that it is meeting your obligations to comply with the statute. Anyway, so next question. Should expenses for resale certificates and/or expenses for transfer fees or moving fees be specifically included in a specially allocated expenses provision? So Lisa and I had different interpretations of this question. Lisa's was about whether or not those had to be included in the resale certificate. Mine was about whether those had to be included in the declaration or CC&Rs. And so the first thing we'd want to do is know more about what you're trying to charge money for. If it's the resale certificate fee, which the statute states can be $275, we believe that that is possible to assess even if it's missing from the declaration, because the statute clearly anticipates charging a reasonable fee of $275 or a second fee of up to $100 if the resale certificate is updated within 6 months. And that's in RCW 6490-640. It's also in 6434-425 for condominiums. Okay. So this is a reminder that once UKIO takes effect, HOAs and co-ops will be required to do resale certificates as well. So for resale certificates, it's pretty straightforward. If you're talking about move-in fees, where the association is charging a landlord or a new resident a fee for moving in, I think that it does need to be disclosed in the declaration to be enforceable. And that's because it's not tied specifically to a service being provided or a expense the association's incurring. If the association is actually incurring specific expenses, it may be possible to pass those on to an owner under the units benefited language or under services provided to an owner language, which many declarations contain. But it would be limited to those amounts. You can't pick an arbitrary number like $500 for a move-in fee and have that work unless it is specifically tied into the, tied into the governing document. And the same would be true for transfer fees. I don't think you can just create a transfer fee to generate revenue for the association and assess that as a cost to an owner unless it is provided specifically in the declaration. So when we are rewriting our declarations, we do include a provision under the section for fees that can be assessed differently than based on the percentage ownership interest. we include a section there for fees related to moving in or fees related to transfer costs the association incurs. We include a section for fees related to maintaining records for rental units. And so if you want to do that, the safest way is to include it in the declaration and include it in the section which is describing expenses which can be assessed to individual owners on a basis different than their percentage ownership interest. Now, I will note that there are management companies that charge a transfer fee when a property is sold. Those fees are generally not addressed at all in the declarations or CC&Rs. Those are not fees being paid to the association. And so they're not something which we are typically involved in giving an opinion on. There is one court case out of California which has essentially provided that management companies can charge fees for services to owners outside of the management contract with the association. And so if you believe that the transfer fee is for a service being provided by the management company, then there is at least that legal support out of California. But because the money is not going to the association, it's not something which, you know, we would be addressing or trying to collect on behalf of the management company. Did you have anything to add, Lisa?
Nope. Let's move on to the next question. When proposing declaration amendments to the membership, do proposed changes show underlining for additions and strike through for deletions, or simply the new proposed wording? What is the best practice? So the basic requirement is that the membership see exactly the new wording of whatever restatement or amended declaration you are doing. Most amendments do not have underlines and strike throughs. That could be helpful to your owners if you know, to see what the changes are, but that's frankly a huge amount of work if you're talking about an entire declaration and trying to figure out how to make it easy to read and not messy by having strike throughs and additions, and you know, you've got these old documents that may have markups and other things on them, so that may not be the easiest thing to read. Our thought is a best practice is probably to provide a summary of the changes. That's what we do. Most times, much more than a couple of pages is not helpful to an owner. If you think about yourself looking at a legal document when you start to glaze over, it's about that point. So that's probably the best thing for a group of owners to see is this is what your declaration says, this is what we're changing, and that may be the end of it. You could certainly spend a lot of money if you wanted to and have your attorneys draft up sort of a side-by-side comparison, but that is not generally how it is done, and it is probably not worth the time for most owners. That's not what they want to see. They just want to know how is this going to affect me, and what are the actual changes, what are the things that aren't going to be around anymore, and what things are going to be around in the documents. I think we have done those kinds of things before, but it's generally not the best practice, or not what is preferred, and certainly not what owners prefer to see. Anything I missed there, Ken? You do these more.
No, I would just clarify a little bit. We do have clients that want much more detail on the comparison between the old and new. And for some sections like insurance, that may be very valuable, but a track changes doesn't function for revising the insurance provision. Right. But we do have, you know, we've tried a couple different kinds of documents to do comparisons where the old and new are side by side on a table, or the new is there, and then we put in a different color the old language immediately below it. If you're doing a simple amendment like moving parking spaces or changing the number of allowed pets, then a track changes document certainly works easily. And that's a way to assure your owners that you're not modifying anything except changing the allowed number of dogs from 2 to 3. And so it really does depend on what you're doing. But I would also offer that if you did a comparison document for the purposes of the board in their reviewing and editing, I would not mail it out to the owners. You know, if you're mailing out already 50 plus pages of the new proposed declaration and bylaws and a 2-page summary and a ballot and a cover letter, you don't want to add another 50 or 70 pages with the comparison document. If you do want to spend the money on a comparison document, we'd recommend you hold it and make it available electronically to those owners who ask. Because otherwise you're going to be presenting them with well over 100 pages of paperwork, and the likelihood that an owner is going to actually go through and then vote on your ballot decreases. And our goal is to try and make it so that the owners are more likely to vote. And we find the summaries with instructions on how to find the detail in the document to be the most successful in getting that done now. So, anything else on that, Lisa?
Nope, go ahead.
Okay. So next question. Another law firm states in their email signature, quote, asked us about planning to amend and restate your documents before then, meaning 2028, to ensure your governing documents are valid. This is based on the change in statute, which is affecting every community with the adoption of Ukiah. So the question is, do our governing documents become invalid if we do not amend and restate them? So again, we're assuming this is because you're talking about the change in Ukiah, and the short answer is no, your documents do not become invalid. You're not required to modify the documents along with the change in statute. In the same way that no CC&Rs for any homeowner association became invalid when the Homeowner Association Act was adopted in 1995. The act created more obligations and specific requirements for associations, but it did not invalidate any of the previous documents, and the statutes did not have to be incorporated into the new documents. Now, it doesn't mean that it might not be easier for you to have them incorporated into the document, and we certainly are helping a lot of clients rewrite their documents to include the documents, or the statutory provisions, because it is helpful to them, not because it is required. So it's certainly something I think every board should be considering. They should be having a discussion about, do they want to spend the money and take the time to revise their documents? It's just that they can choose the answer is no. They can decide it's not worth the money that the attorneys want to charge in order to update their documents. You know, we usually recommend clients budget in the $7,000 to $10,000 range to update their declaration or CC&Rs and their bylaws to become compliant and include the provisions that are in the statutes. There are ways to do it for less money. If you want something like that comparison document we talked about, you need to plan on budgeting more. We know that some other law firms are recommending that their clients budget at least $20,000. We know there are some attorneys who just won't do it for less than $20,000 because they just don't like doing them. So it's not something which has a specific urgency to it. You know, you've still got, 3 years. And so it's something that you can consider. There are some provisions that clients want to get early because they are beneficial to them. One of those is the borrowing provision. And so if you've got a specific need, you might want to adopt it early. You can adopt it early with a 3-page document that just says, we're now governed by Ukiah. You don't have to put all the changes into your main declaration or CC&Rs. So it is something to think about. I am going to be doing a presentation with Katie, one of our attorneys, at CA Day, talking about those things which you must do under Ukiah and those things which you can no longer do under Ukiah. but that does not, it's not going to address all of the things which you might do if you chose to under Ukiah, like assessing the costs of your insurance deductible to individual owners. That is certainly allowed under Ukiah, but it does not happen just because Ukiah takes effect. Anything you want to add?
Nope, that covers it. Let's see, next question. Regarding condos without a rental cap, when declarations with a clause that says nothing shall be done within the unit that will increase the rate of insurance without prior written consent, would all landlord owners be accountable for the increased portion of the insurance and the percentage going forward? Meaning, if the insurance is going up because we have a lot of rentals, can we charge the landlord owners for that increase, and what percentage increase could we charge them? The question is fairly specific because we don't have the declaration in front of us to know exactly what that is, but generally speaking, we're in a community and we have shared expenses. It would be difficult, and so we kind of expect that if things affect the bottom line of our association, that will change the budget, and those costs are shared by the community. However, it is, I suppose, theoretically possible to figure out that rentals are what changed the insurance rates. But as Ken and I discussed before this, the challenge is deciding which owner tipped the scales. So if you've got 4 rentals now and all of a sudden you've got 6, was it the 5th one that made the increase? Was it the 6th one? It wasn't the 1 through 4 because the rate was the same at that time. So I think you kind of have a proof problem. And it is hard to determine which of those owners made that change. Certainly, this is something you could address in an amended or restated declaration. That increased costs caused by a unit, could potentially be passed on to that particular owner. But I think that you're getting into some pretty specific discussions there. But I think that the main impetus or the main answer to your question is maybe, but it's going to be hard to figure out which of those owners, if you could tell that one unit is really a problem, then maybe you might have a conversation to have with your attorney about whether or not that's a possible shared expense. But I think it is probably a difficult determining factor to see which or how to share those increased costs. Ken, did I answer that at all or mess it up? Anything you want to add?
No, I think you got it right.
Okay.
One of the challenges that I would see is that even though the question says that the percentage increase can be documented and quantified, I have never seen an insurance premium increase where they documented what the specific causes were for the increase. So we're seeing a lot of clients with increases that are related to just inflation, the increased cost of rebuilding. We've seen clients with increases which tie to the number of claims they have, that tie to the type of piping that they have for their water system. And what we don't see is the insurance company detail out a specific dollar portion for each of those different factors. They just send an increase of 45%, and that's their offer to insure the building. And they don't want to give any further explanation. So I think it'd be really difficult to document the specific amount. And I think you'd probably find it ends up being a fairly small dollar amount. And if it was a small dollar amount, like, I don't know, $20 a month per unit, then it might actually be that your landlord owners wouldn't object to it. But that's another portion of this, which is it's a challenge, is that you can try and assess it. Then the question is whether or not the landlords are willing to just accept that as part of the cost of doing business, or whether you're going to get yourself in a legal battle, which is going to cost you more than the increase in your insurance premium. Anyway, next question. Electronic invoices for HOA dues. Can a management company exclusively provide invoices for HOA dues via email despite mailing out the annual budget each year? Question mark. We want to understand if this is compliant with any existing regulations or best practices. Okay. So we've had a lot of discussion about what qualifies as notice. And we have stated repeatedly that notice is not effective electronically unless the owner has opted in or agreed to accept notice electronically. Okay. So part of what we don't know is whether these electronic invoices are just reminders, which are not required by your declaration, in which case email's fine. If it's, the same as me getting the email from CenturyLink for my cable bill saying they sent me a cable bill and I owe X dollars, they're still sending me a paper bill to pay, which is the formal notice. The budget process with the ratification qualifies as the notice requirement to owners to pay every month. You don't have to send a monthly invoice for that process to have been completed properly. I do think you need to have sent a notice after the ratification to confirm to owners what their monthly payments are, because until it's been ratified, it is not actually due from the owners. So I'd certainly say best practice is you're going to send out the budget to people to be ratified. You're going to hold your meeting. Then you're going to send out another notice to each owner telling them how much they owe each month. That way we can collect it without being challenged successfully. Okay. But if you're just trying to do a polite reminder to people to pay their monthly dues, I think you can do that electronically. Lisa, more thoughts on that?
I would just say that, make sure that your, as Ken mentioned, that your budget ratification notices are sent out properly. We've talked about this in the past that, if an owner has opted into electronic notices, potentially you could email them those, but I think we think the gold standard is to mail it, do the actual proper either hand delivered or mailed notice of those types of things. If your budget is properly ratified, and we've had lots of conversations about what that means as well, then the assessments are due and payable once you've provided the notice to the owners that the budget has been ratified. So I just, make sure you follow the appropriate steps. And then as Ken said, it'd be nice to send them a notice, but I don't think you're required to. For sure, if they haven't paid, follow your collection policy or rules as to how to do that, to make sure that they are paying their assessments timely and that you can properly collect them. But I think that is it on that one.
Yeah, I would just add, there are a lot of other reasons you might email owners to just keep them informed, to tell them about missed garbage pickups or about construction work that's going on, or about when fire sprinklers or smoke alarms are going to be tested by a vendor. And for the most part, email is a convenient and effective way of communicating with your residents and getting their cooperation and keeping them informed. It's just that you get these exceptional circumstances, and payments are one, where you need to make sure you followed the procedures and given notice as provided by the declaration.
All right, next, is that me for the next question? Yeah.
Yeah.
Reserve study requirement. If a community owns a small access road but has no other significant common areas aside from small green patches, does this trigger the requirement for a reserve study under Wakaiowa? Our community only has 9 homes with total annual assessments of 14,500. Additionally, the houses were built before the enactment of Wakaiowa. We'll start out by saying that it doesn't matter when your community was formed. The application of Wakaiowa to reserve studies is for everyone. And what Wakaiowa says for this is that a reserve study is required in general under 64-90-545 subsection 2. Unless your common interest community has only nominal reserve costs, or when the cost of the reserve study or update exceeds 10% of the association's annual budget. We discussed previously that the costs of reserve studies are usually at least $2,000. So in this case, it's possible, I mean, that is more than 10% of the annual budget, it is possible that this community could be exempt from having to do a reserve study. If the costs of maintaining the road are fairly nominal, you could also be exempt. Roads generally, however, do have fairly high costs of upkeep, even though it's fairly infrequent. So it may be that, every 20 years or so, you need to do something that costs a lot of money to maintain or preserve the road. There is a very, that this is one of the few statutes that actually tells you that if you don't do what it tells you to do, there's not much risk to you. So what the statute says is if you fail to do a reserve study, the remedy is provided in 64-90-555 that 20% of the owners can basically demand that the cost of a reserve study be included in your next budget. If that budget's then ratified, then you do the reserve study after that. So essentially what we're saying is you may fall into one of the exemptions, but even if you fall into one of those exemptions, if you have enough owners that come up and say, we really think you need to do a reserve study, all you have to do is put that in your budget. If budget passes, you do the reserve study. There isn't a penalty or other impact on your association. So, this is pretty fact specific. If you have further questions about this, you may want to talk to your attorney or legal counselor for information on this. But generally speaking, if you fall into one of those exemptions, you may not have to do a reserve study, and the risks of not doing one are fairly low. Ken, anything to add on that?
Just that you still are required in your budget process to disclose
Yes.
that you don't have a reserve study, and that creates risk for the owners. And you'd still be required in any resale certificate to state that you do not have a reserve study. And there's a very specific paragraph you're required to include that states that there is risk to the purchaser, that there will be some kind of special assessment. And so you want to make sure that if you are intentionally avoiding doing a reserve study, you are informing your owners that there is no reserve study and that there is a risk related to them. Okay. Next question. Our current board has concerns regarding the Corporate Transparency Act regulations being implemented with a due date of January 1, 2025. We understand active board members must provide updated changes to their information that they provide with FinCEN within 30 days. How are these updates handled when a board member resigns? Is FinCEN notified of the resignation and that the board member is removed from their system and no longer responsible for reporting, or are they expected to keep reporting after resigning? Okay. So we've got a couple parts of this. One is that we're still recommending you hold off on compliance because there's at least a chance that the legislature will change the law, or that National CAI's lawsuit to try and block its implementation will be successful. And it's just not, it's too early to know. Even though we did tell people to start considering compliance in October. Okay. So we don't think that, other than notifying the government that a board member has left their obligations for the board, that the association has to do more. And we don't think it was the intent that once you've signed up in the system, you are forever bound to continue giving the government this information, even after you've stopped being the beneficial owner of one of the entities, meaning you've left the board. Okay. So the other thing that we do try and, I guess, remind people is that the government already has all of your information. Between the Social Security system and the IRS and anything else you signed up for. They know who you are and they have your information. The only thing that this is really changing is it's tying the board members' individual information to the association. And I guess under the theory that maybe the association is laundering money for you. So there's really no good reason for HOAs to have been included, but the way the law was written, it was so broad and encompassing that all the HOAs got swept in. Okay. So if you want to keep your information private from your neighbors and your board and your management company, you can do that by giving your information only to the government and then giving an identifying number to your board or manager. And so it's possible for you to retain some anonymity or, privacy from your neighbors. They don't have to know your social security number or your income. So the other thing that has come up this week is that we know that one of our competitor law firms sent out letters to a whole bunch of associations, apparently including some of our clients, offering to help the board comply with the CTA for a fee of $150. And all it required was that you give them every bit of information required for the board members to submit to the government. And I guess my response to that is that it's sort of like asking a law firm to file your annual notice for the Secretary of State. You can go online and do it. You can update all the information yourself directly. You don't need a law firm to do it. But I guess if you want to pay the law firm to do it, you can certainly do that. I'm a little hesitant to tell people to have two law firms. So if you want a law firm to do it, I would recommend you use the same law firm that you're using for other legal advice or services. Certainly, if you've got a law firm doing the Secretary of State stuff, that would probably be the better choice than to hire an independent law firm to do this. Any other thoughts, Lisa?
Nope. Just go on to the next one. Board doesn't want to assign a board member to take meeting minutes. What are some solutions? The first thing I'd say is make sure you've looked at your bylaws and governing documents, your declaration, to make sure that there aren't officer descriptions, requirements, things like that. But barring any requirement to have a secretary who takes meeting minutes, that's certainly something that you can enlist the help of your manager to do. You could potentially pay your manager to sit there and take those minutes. You could enlist volunteers from the community to rotate in, or have a specific person who sits there and takes the meeting minutes. We've discussed this in the past, but the meeting minutes are meant not to be a verbatim recording of what's happened at that meeting. It's merely just what actions were taken by the board at that meeting. So for example, you'd basically have the agenda in front of you and just jot down next to each thing, motion made by so-and-so, passed, et cetera, et cetera. So that is certainly something that a volunteer from the community or your manager could do. It doesn't really matter who prepares them, because they are then approved by the board or not at the next board meeting. We have some clients who do record the meeting so that the person afterwards has more time to prepare the minutes. But again, because you don't need to write down and transcribe what actually happened at the meeting, that may or may not be useful to you. And there may be some other issues with keeping recordings of those minutes that we don't need to get into now. But the basic thing is, it doesn't have to be a board member who takes the meeting minutes. It could be anyone who wants to volunteer to do that, or anyone you want to pay to do that. I haven't seen this come up before where someone absolutely refuses to be assigned that role. But I think you can fairly simply find someone who's willing to just take a few notes and prepare those before the next meeting. Anything to add, Ken?
No, I think you've covered it.
Okay.
Next question. When a family member is renting a unit in an association with a rental cap, is there a limit as to how distant a relative can qualify before we would have to apply for rental status? So the first response I'd have is look at your governing documents, because it may define fairly precisely what the limit is on a relative. Frequently it will state, parents or children, siblings, spouses of those. And if there is a definition in your document, then that is the limit. If it just says a relative, then you could make a rule or adopt a policy as a community on what relative means so that you could define it. The lowest risk way to deal with it would be to define what a related party is or a relative in your document and draft an amendment to the declaration. It may be a challenge under the new statutes, and that's in part because there's a new statute which was just enacted in June, which says that associations cannot prohibit restrictions on unrelated parties or unrelated persons that may occupy a unit. And it specifically states the number of unrelated persons that may occupy a unit, but it may be that this could be used by a landlord to allow them to rent to an unrelated party. And we don't know what the legislative intent was, other than that they are trying to broadly reduce homelessness. And so anything which is an impediment to a person renting becomes subject to an interpretation of the law that is going to favor renting to them. So it's a brand new law. No one really knows how to affect it. Lisa, do you have any thoughts on that?
And would this, would contacting your insurance agent be something you may want to do to see, or I don't know if it's your insurance agent, but to figure out whether that would affect how many rental units there are, if it's occupied by somebody else, or is it purely a function of your language in your declaration, your governing documents?
Well, I think this one is generally purely a function of how your documents read and your board interprets it, because the banking and insurance industries generally don't have definitions for what qualifies as a owner occupied or as a rental. We know the banking industry just asks the association or the manager, how many rentals are there? And if you don't count a family member as a rental, they don't question it. So it leaves it open for the board to make a reasonable interpretation of what a relative is and then apply it in a non-discriminatory manner. So anyway, that's our last question that came in. Chelsea, did we have anything that came into the chat?
Not a whole lot. We do have a couple people asking about yours and Katie's presentation coming up, and asking if there will be anything, if the presentation will be available in writing, or if we'll be recording it and putting it up somewhere.
I don't know that CAI is going to record them. I think they have recorded some in the past and made them available, but that's entirely up to CAI, not anything that we have an option for. And I would guess that CAI would want you to pay to be a member of CAI in order to review it, because it is the funding from people paying to be at the conference that keeps CAI afloat. One of the things we're hoping to do is get a checklist kind of the musts and can'ts, which we will be sharing at the presentation. And I think we can make that available to people after the presentation's done. But if we don't,
And that is it. Oh, wait,
so
someone just
one just
posted
came
one.
in.
If there's not a specified election process noted in an HOA's bylaws, how should the HOA hold their election process? If someone attempts to nominate from the floor, is this something they can do, although it's not specified by the bylaws?
So I think that the statutes now provide some fairly specific guidance on voting by members. And it provides very specific procedures for voting by mail, I know for sure. So that might be the easy way to resolve it, is you do your elections by mail. Normally I would have said that if the documents are silent and you are holding a meeting for an election, that you would provide for nominations from the floor before the meeting took place. But I'd probably need to know a little more detail to give legal advice. The the idea is that you are going to make a process easier for members to elect the board of their choosing rather than set up impediments. And so if you're refusing to allow nominations from the floor, I'd want to know that you had provided information in advance telling people how to nominate themselves or their neighbors, and specifying in advance that you are not going to take nominations from the floor because you are going to be doing an election process via Zoom or via some website or however you're going to do it, that was not going to accommodate nominations from the floor. But I'm okay with us ending early. So if
There was a follow-up question on that question. Wouldn't the RCWs prevail?
well, if the RCW has a specification, it would. I don't think the RCWs address whether or not nominations from the floor are allowed or not if you're holding the election at the meeting. So if you want an interpretation of that, you need to give your facts to an attorney and let them give you a legal opinion. All right. Well, so we'll be done for today. Thank you everyone for joining us, and we'll see some of you next week.
Thank you. Goodbye.
Thank you.